My name is Joe Stewart. I teach in the political science department at Clemson University in South Carolina. Welcome, congratulations, and thank you for persisting through what's a new experience for all of us.
I'm Tim Moore from the Center for the Study of the American Constitution at the University of Wisconsin-Madison. It's great to be here. And I didn't know your teacher was the Unabomber, but yeah, great to be here.
Okay, would you introduce yourselves, please?
Hi, I'm Jordan Met. I'm a junior at Greenwich High School.
I'm Dylan Minnie. I'm a junior at Greenwich High School.
I'm Ryan Hirsch. I'm a junior at Greenwich High School.
I'm Nikita Cotton. I'm a junior at Greenwich High School, and we are joined by Coach Hull and Coach Moore.
Oh, very good. Welcome to all of you, and congratulations on making it here. And yes, congratulations on bearing with the technology in all of this. So I actually think it's worked pretty well. You probably, maybe you've seen other competitions from your team, but so far it seems like it's going fine. So we'll keep our fingers crossed. So this is Unit 2. I'm going to read the question and we will get started. So the Unit 2 is, how did the framers create the Constitution? And the question is question 1. The states sent delegates to the Philadelphia Convention to join with other states, quote, in devising and discussing all such alterations and further provisions as may be necessary to render the federal Constitution adequate to the exigencies of the Union. To what extent, if any, did the delegates follow their instructions? What experiences of state governments under the new constitutions after independence might have influenced the creation of the Constitution? And do the decisions of the U.S. Supreme Court function as a continuing constitutional convention? Why or why not? You may begin.
At the time of the Philadelphia Convention, Americans were demanding a change from the weak federal government under the Articles of Confederation. The Articles' inability to act upon threats to the nation, such as Shays' Rebellion, instilled fear in much of the public. Due to such events and difficulties, delegates were sent to essentially revise the Articles of Confederation. According to the Center for the Study of the American Constitution, the closest the delegates came to revising the Constitution was when Madison proposed the Virginia Plan and said it was an upgrade to the Articles. The delegates clearly had a larger plan in mind. They put the Articles aside and drafted a whole new document, the U.S. Constitution. This was a clear divergence from the original purpose of the convention and proves how the delegates failed to follow their directions. The delegates hoped to create a strong, unified central government without taking away much power from the states. However, they also hoped to make the responsibilities of the federal government very clear. James Madison highlighted in Federalist 14 that, quote, the general government is not to be charged with the whole power of making and administering laws. Its jurisdiction is limited to certain enumerated objects, meaning that the federal government had to be limited in its capabilities while still maintaining its power. Overall, the delegates didn't follow the instructions, however, they ended up creating a system that has functioned well for over 200 years.
When the delegates arrived at the Philadelphia Convention, they brought with them the building blocks of their own state constitutions. These building blocks included the ideas of popular sovereignty, separation of powers, checks and balances, an amendment process, and a Bill of Rights. Behind these ideas was a unifying concern over how much control the federal government could usurp without a limit to its power. Out of a desire to protect their citizens, most of the colonies had already produced their own written sets of guaranteed rights and set in stone that such natural rights couldn't be taken away by anyone or freely given up. The 6 most commonly listed rights by the states were free exercise of religion, trial by jury in criminal cases, freedom of the press, due process of law, no excessive bail, and no unjustified searches and seizures. Through the Philadelphia Convention, many of the same rights from the state bills of rights eventually ended up in the U.S. Constitution. Ultimately, the impact of the state constitutions cannot be overlooked, as their influence on the creation of the U.S. Constitution has proven to be immensely important throughout history.
Although the delegates of the Constitutional Convention initially agreed that the judiciary would not be a part of a council of revision, Marbury v. Madison was able to redefine the role of the Supreme Court. In this landmark case, Chief Justice John Marshall enforced federal judicial power and the idea of the court as a legal body. The notion that the Supreme Court is a continuous constitutional convention is entirely accurate, and that the judiciary is always redefining and revising the words of the Constitution. Akhil Amar states that there is an unwritten constitution beyond the text, and thus when interpreting the Constitution, the Supreme Court must look at both the text and the intent of the founders. Both the conventions and the court follow the same structure of interpreting and making decisions based on the rationale and constitutionality of the lawyers' or delegates' arguments. It is essential, as Jefferson argued, that the government should quote, provide in our Constitution for its revision at stated periods, end quote. As time change, our Constitution must be updated and should be looked at under the same microscope as the creation of the Constitution during the convention.
However, this does not come without its controversy. Many feel that a body of 9 politically swayed individuals should not be responsible for deciding the legal interpretation of the Constitution and its application in modern day. Despite Hamilton's intention to rid justices of political bias by instilling lifelong jurisdictions and his ideas behind that decision, as explained in Federalist Paper number 78, the Supreme Court has become inherently political. Additionally, because it is so difficult to pass a constitutional amendment in times where the states are divided within a country, the power of the Supreme Court's rulings become extremified because the check on that power would be a constitutional amendment. In conclusion, the Supreme Court does act as a continuing constitutional convention. However, this does not come without its controversy.
Oh, perfect. Okay. So I'm going to ask the first question. The resolution of the Confederation Congress that approved the Constitutional Convention was a little bit different from the one that's quoted in the question. And it includes this. It says they're to render the federal constitution adequate to the exigencies of government and the preservation of the Union. So my question to you is, when you've got two conflicting sets of instructions, either of which could claim to be authoritative, which one is the correct set of instructions? How do you decide?
Well, it's important to note that there often is this question of security versus liberty and what the federal government should be protecting at its most important. And I believe that, as you say, these are two differing authoritarian decisions, but it is the power of the best solution would be to find a compromise between the two and to use that solution as a continuing precedent.
So, I mean, do you think when the delegates didn't follow, you said they didn't follow instructions, but if they've got conflicting sets of instructions, doesn't that make it hard to say, well, you didn't do what this instruction said? They can say, well, we did what that instruction said instead, right?
Right, but that's where my partner Dylan was talking about the compromise between the two, because obviously there's a ton of divide within the Constitutional Convention. People are super scared to have a repetition of what they just fought to get out of, and the Articles of Confederation, which was also argued to be like a humiliation in Federalist 15. So in order to find that balance, yes, some people did walk out, but in the end, they did come together to create these 10 amendments, with the first 10 amendments, especially the last one, the 10th Amendment, which gave states the power, or like powers that weren't identified.
And by doing so, by finding that compromise, they weren't obeying either of the orders. So they were not following their instructions, but by doing so, as my partner Nikita stated in his testimony, by finding that compromise, while they may not have been directly following the instructions, they were able to create a document that has functioned for well over 200 years.
Okay, thanks.
I'd like to ask a question about the anti-federalist criticisms of the convention, not of the Constitution of the convention, but the convention itself. Which criticism of the anti-federalists do you think is most valid or makes sense to you in that regard?
Well, I think that the anti-federalists had a valid point in that they felt that the federal government was gaining too much power. And I think something that also scared them might have been the necessary and proper clause, since that's so vague. It's as if the federal government can do anything that they want.
Let me interrupt. I'm asking about the convention itself. You're right, Jordan, that the anti-federalists were concerned about those two things you mentioned. But about the convention itself.
I believe that the anti-federalists were probably hesitant of the secrecy rule and essentially having to keep like the convention a secret from like the outside sources while they were still drafting the document, essentially, in order to like minimize influence.
Additionally, at the Constitutional Convention, it was a group of elite white men, and this was a concern for many people as this at the time did not represent the majority of the population. And as we have seen through several constitutional amendments and changes, that people did find that the writings of these elite white men to be not pertaining to all persons, with the extension of property, of non-property owning men could vote, and the 19th Amendment. And even today, a lot of people challenge the Constitution because of who wrote it and because of the framers, and the actual people that were at the convention may have been a challenge to the Anti-Federalists.
Adding on to Nikita's idea, even today, there's still issues with privacy and concerns over privacy continuing from Constitutional Convention. Even today, like in cases like Griswold v. Connecticut and Roe v. Wade, we see issues of privacy and concerns with the national government invading people's personal privacy and secrecy.
Okay, thank you. You talk about the Supreme Court having become more political. Here I am, as you can tell over my shoulder, sitting in the chambers of the old Supreme Court, harkening back to the good old days that never were. I mean, hasn't the Supreme Court always been a political institution?
Yes, it has, but as our country becomes more divided, as I stated in my testimony, the Supreme Court's rulings become more powerful, because a check on the Supreme Court's precedent would be a constitutional amendment, but needing 3/4 of the states to pass a constitutional amendment in our current state with such a division between the two parties in America would be very difficult, and it would have to be a very nonpartisan issue.
And you get the last word.
Okay. Thank you.
Thank you.
You want me to start out, Jack or Joe? I mean, how do you
Go
want?
for it.
Go
Jim.
ahead.
Okay. I think your opening presentation was very solid, and I especially liked the fact that you're essentially saying Hamilton's Fed 78th isn't valid. I get a warm feeling